Assalamualaikum warahmatullahi wabarakatuh, and good morning or good evening or good night, depends on when you are watching this video. Allow me to introduce myself first. My name is AMIRAH BINTI ANUAR from DPM 5E. I am going to present about the procedures of repossession and how it could protect the hire. So into this video, I am going to make a bit of role play that you will be my customer and I will be your asker that will be giving out information for you. So let's not waste any time. Let's get started. Hello, welcome to Law Department. I'm Nabila as your helper. How may I help you? Oh, you want to ask about the repossession? Okay. May I have your ID first? So this is your ID. Wait a second, yeah. So, what can I see in here? You are the first timer in here. Am I right? Yeah. So, since you are the first time in here, I am going to proceed you with Miss AMIRAH at room 47. So, all you have to do now is please be seated and we will call you in a bit. Okay, thank you for your cooperation. Come in. Oh, hi. Hi to you too. Please have a seat, miss. Alright. Good morning to you too. Okay, so I heard that the front desk lady told me that you are here to ask about the repossession. Am I right? Yeah, alright. So I will just check. Wait a minute, yeah. Okay, about this, and I will give you this as your references so that you could understand me more. Okay, are you good with that? Okay, so can we start? Yeah. Okay. Okay, about repossession, I am going to explain about the definition of repossession and hire purchase, procedures of repossession, and how it could protect the hire. Alright, first and foremost, repossession is the action of retaking possession of something, in particular when a buyer defaults on payments. Meanwhile, the hire purchase is basically an agreement wherein an owner agrees to hire goods to the hire with an option for the hire to purchase the goods. Generally, hire purchase means gaining the benefit of the possession and use of goods before one has fully paid for them. Right, now I'll move to the before repossession. Section 16(1) requires the owner to supply the hire with a notice of repossession. In other words, notice of repossession must be given to the hire when goods are to be repossessed. Before the owner exercises his right to repossess the goods, the owner must first assure that the balance of the loan to be paid by the hire must be more than 1/3 of the purchased goods hired. By fulfilling this requirement, only then the owner will have complied with the requirement that the hire has defaulted 2 successive installments. Under Section 16(1), the owner must serve the hire a 21-day notice of intention to repossess in writing as set out in the 4th schedule. The written notice must be serviced in compliance with Section 43 of the Act. The owner can retake possession of the goods only after the expiry of the notice period and if the overdue installments are not settled by then. In Pang Brothers Motor Sdn Bhd v. Lee Ike Sang, where a car was taken by the respondent on hire purchase agreement with the appellant, the respondent failed to pay the installments due to the appellant issued a notice under Section 16(1). The issue was whether the notice was in fact served. The court held that Section 16 clearly specifies that The period before which can seizure can take place should be not less than 21 days after the service of the notice. However, the date specified in the notice was 2 days short of the statutory minimum requirement, and the notice was therefore bad in law, even if served, and its effect was therefore null and void. In addition, there appears to be no time limit within which to repossess upon the expiry of the notice, so long as the arrears of installments and interest thereon remain outstanding. Section 16(1) does not specify any time limit within which an owner must repossess after service of Section 16(1) notice, so long as the provisions of Section 16(1) of the Act have been complied with. The owner repossess the goods, and the relevant notice does not cease to be effective merely because the owner did not actually repossess until 2 years after service of the said notice, so long as the arrears of installments, including arrears of interest due on overdue installments, remain payable and unpaid. Section 16(1)(a) provides that if the payment of installments made amounts to more than 1/3 of the total cash price of the goods comprised in a hire purchase agreement, and there had been 2 successive defaults of payment by the hire, the owner should not exercise any power of taking possession of the goods comprised in the hire purchase agreement arising out of any breach of the agreement relating to the payment of installments, unless he has obtained of the court to that effect. Hence, Section 16(1)(a) requires an order of the court to be obtained by the owner before repossessing the hired goods if the balance of the loan is less than 1/3 of the purchase price of the goods. This section governs a situation where the hire is deceased. Although Section 16(1)(a) is silent regarding the applicability of the procedure for repossession as laid down in Section 16(1), such provision is applicable in the circumstance as provided in Section 16(1)(a), except when the notice for the breach is being effected under the 4th schedule. It must be stated that the nominee of the deceased should be the receiver of the notice. Section 16(2) provides that the owner is excused from complying with Section 16(1) where there are reasonable grounds for believing that the goods will be removed or concealed by the hire contrary to the provisions of the agreement. The onus of proving the existence of those grounds lies upon the owner. Section 16(2) makes sense because hires who have defaulted in their monthly installments have been known to disappear and remove the goods or conceal them in order to prevent the owner from repossessing them. Under Section 16(7), it is provided that before the owner of it or his agent repossesses the goods, he must, in addition to complying with the provisions of the Act, comply with any regularization may be prescribed. Under Section 16(17), it is provided that before the owner or his agent repossesses the goods, he must, in addition to complying with the provisions of the Act, comply with any regulations as may be prescribed. Under the Hire Purchase Regulations, 1976, Rule 3(1) requires the owner to send a notice to the hire informing him that the owner intends to repossess the goods. A copy of this notice must be sent to the controller of hire purchase. This notice is in addition to the notice contained in the 4th schedule. Section 16(a) provides that the hire who returns the goods comprised in a hire purchase agreement within 21 days after the service on him of the notice in the form set out in the 4th schedule shall not be liable to pay the cost of repossession, the cost incidental of taking possession, and the cost of storage. However, it is important to note that upon service of the notice under the 4th schedule and after 21 days had elapsed from the service of the notice, the owner may take the possessions of the goods. Right now, we move to after repossession. Within 21 days after repossessing the goods, the owner is required under Section 16(3) to serve on the hire and every guarantor of the hire a notice in the form set out in the fee schedule. Section 16(3) is mandatory, and if the owner fails to comply with this section, the rights of the owner under the hire purchase agreement will cease and or terminated. This is clearly spelled under Section 16(6) of the Act. Therefore, it is important for the owner to serve a notice in the form as set out in the fee schedule on the hire and every guarantor of the hire within 21 days after the owner has taken possession of the goods. The owner is also required under Section 16(4) to deliver to the hire a document acknowledging receipt of the goods. The document must set out a short description of the goods, the date, time and place where the goods were repossessed. This is by virtue of Section 16(5). As mentioned earlier, if the owner fails to serve the notice in the form set out in the fee schedule, his rights under the hire purchase agreement thereupon cease and determined. This is by virtue of Section 16(6). But the owner may apply to court immediately for an extension of time as contained in Section 49 of the Act. Such an application shall not be done ex parte because the hire's right will be prejudiced. However, if the hire then recovers the goods repossessed, the agreement has the same effect as though notice had been given. In other words, the hire purchase agreement is deemed to continue in force between the parties. Under Section 17(1), it is provided that where the owner has taken possession of the goods under Section 16, he must not, without the hire consent, sell or dispose of them or part with possession thereof until the expiration of 21 days after the days of the service of the notice set out in the fee schedule. Section 72. An owner who sells or disposes of any hired goods or parts with possession of such goods in contravention of Section 17(1) should be guilty of an offence. In other words, Section 17(1) requires the owner to retain goods repossessed. He is prohibited to dispose of the goods within 21 days after the date of the repossession of the goods. In addition, where the owner has taken possession of any goods, the hire shall be liable for the cost of repossession. The hire has no rights to deny his liability to pay the cost because it's stipulated in the hire purchase agreement between the owner and the hire. The hire's right is only the extent of contending total costs incurred when the owner took possession of the goods. In 𝐜𝐫𝐞𝐲 v. United Engineers, the court observed that the appellant hire had contractually undertaken to pay such costs and expenses, and he could not thereafter dispute his obligation to pay the actual costs incurred. Section 17(a) and 17(b) deal with the issue of permit for repossession. Only a person that is given a permit can execute the repossession process. The permit is issued by the controller, which means that it is directly controlled by the government. Therefore, when the owner engages an agent to execute repossession, that particular agent must have a permit. Section 18(1) deals with hire's right when goods are repossessed by the owner. Therefore, when the owner repossesses goods under Section 16, the hire may, within 21 days of receipt of the fee schedule notice, require the owner by written notice to redeliver the goods to him or require that the goods to be sold to a person introduced by him. Also, the hire has the right to recover from the owner the difference, if any, having regard to the total value of the goods, inclusive of the amounts already paid and the net amount payable. The owner is not, however, entitled to recover any sum which, when added together to the value of the goods at repossession and the amount already paid, exceeds the net amount payable for the goods. This is by virtue of Section 18(2) of the Hire Purchase 1967. It is equally important to note that the net amount payable for purposes of Section 18 is the total amount payable less statutory rebates for terms, charges, and insurance. The value of goods is the best obtainable price, or the cash paid by the person introduced by the hire, less reasonable cost of repossession, including storage, repair, and maintenance charges, and reasonable cost of selling or attempting to sell or otherwise dispose of the goods. This is by virtue of Section 18(3)(a) and B of the Hire Purchase Act 1967. Under Section 18(4)(a), it is provided that where the owner intends to sell the goods by public auction, he must serve on the hire a copy of the notice of such public auction not less than 14 days from the date that he said that the said auction is to be held. Therefore, when the owner takes possession of goods and required to sell them by public auction, he is responsible to ensure that the goods are sold at the best market price. If the owner fails to comply with such requirement, the hire will be stopped from reducing his losses. In addition, Section 18(4)(b) echoes the sentiment that if the owner intends to sell the goods otherwise than by public auction, he must give the hire an option to purchase the goods at the price which he intends to sell if the price is less than the owner's estimate of the value of the goods repossessed. If the owner fails to comply with this requirement, he should be guilty of an offence. Under Section 18(5)(a), the hire will not be able to recover anything from the owner unless he acts fast. He must, within 21 days of receiving the notice under the fee schedule, give the owner a notice in writing setting out the amount which he is claiming under his section. The notice can either be signed by hire himself or by his solicitor or agent. On the other hand, Section 18(5) states that after sending the notice to the owner, the hire must then commence action in court not later than 3 months after the notice had been sent to the owner. If before proceeding under Section 18(5) are commenced by the hire, the owner serve on the hire an offer in writing to pay the amount claimed, the matter will be settled if the offer is accepted by the hire. If proceedings are commenced, the owner may pay the amount offered into court, and in this event, he is entitled to the same rights as if he had tendered the amount to the hire. This is by virtue of Section 18(6) of the Hire Purchase Act 1967. In other words, at any time before proceedings against the owner have been commenced by the hire, the owner can make any offer in writing to the hire any amount in satisfaction of the hire's claim. If this offer is accepted by the owner, the dispute ends there. But if the offer is rejected by the hire, the owner is entitled to pay the amount into court. Section 19(1) deals with the hire's power to regain goods repossessed. Under certain circumstances, the hire may regain goods repossessed by the owner if, after 21 days of giving the notice in the fee schedule, the hire pays or tenders to the owner the amount due, remedies any breach, and pays or tenders to the owner the reasonable costs and expenses of an incidental to the repossession and return of the goods to the hire. the owner is obliged to return the goods to the hire. If the hire is able to do all of that, the law then requires the owner to forthwith return the goods to the hire, and thereafter the relationship between the hire and the owner shall be as if the breach has not occurred and the owner had not repossessed the goods. It would suffice to note that by virtue of Section 19(2)(a) and (b), it is important to note that if upon return of the goods to the hire does not remedy any breach, the hire has no right to repossession unless by written notice given at the time of return of the goods. He specified the breach and required the hire to remedy if it and the hire has failed to do so within the time specified in the notice or within 21 days, which is longer. Alright, now we move to the rights of hire or repossession. The owner can repossess the goods from the hire in the event of the hire's default. The owner can do so by physically retaking his goods, provided he does so peaceably, or by filing an action in court. Such a drastic step by the owner can cause hardship to the hire who had paid a substantial proportion of the value of the goods, but who, due to financial constraints, could not continue making the monthly payment toward the end of the period of hire. The Act is intended to overcome such a problem. Repossession happens when there is default by the hire and in most instances for non-payment of installments. Successive defaults of payment by the hire and the owner has served a notice in writing in the form of fourth schedule, and the period fixed by the notice has expired, which should not be less than 21 days after the service of the notice. Section 16(1) of the Act. Second, if the payment of installments made amounts to more than 75% of the total cash price of the goods and there had been 2 successive defaults of payment by the hire, the owner should not exercise any power of taking possession of the goods unless he has obtained an order of the court to that effect. Then, when an owner has obtained an order of court under subsection 1A and he has served on the hire a notice in writing in the form set out in fourth schedule, and the period fixed by the notice has expired, which should not be less than 21 days after the service of the notice, the owner may exercise the power of taking possession of the goods. In addition to the fourth schedule written notice, the owner shall serve to the hire a notice informing the hire that the owner intends to take possession of the goods. This notice shall only be sent after 14 days of servicing the notice of fourth schedule. This notice shall be sent by registered post. After the expiration of the period fixed in the notice, the repossession can be executed. The person who undertakes repossession must obtain a return permit issued by the controller of hire purchase. Where the owner takes possession of the goods, the owner should deliver to the hire personally a document acknowledging receipt of the goods. But if the hire is not present at that time, he must send to the hire immediately after taking possession of the goods that receipt. A hire who returns goods comprised in a hire purchase agreement within 21 days after the service of fourth schedule should not be liable to pay, first, the cost of repossession, second, the cost incidental to taking possession, and the cost of storage. Alright, so my video has finally come to the end. I want to say thank you so much for your cooperation and for listening for my presentation until this part. I hope my video presentation will be helpful for you. And if you have any suggestion, please comment down below. Alright, I think that's all from me. Till we meet again next time. Bye. Stay safe, take care, and please wear a mask and hand sanitizer. Alright, that's all. Bye.